Good afternoon and good morning to those of you in earlier time zones. I'm Jim Duff, the Executive Director of the Supreme Court Historical Society, and it's my pleasure to welcome you today to the Society's virtual program platform for the latest in our ongoing series of Civics and American Democracy. This is just one of the many paths we're taking to promote civics literacy and learning, along with the history of the Supreme Court, the Constitution, and the judiciary. You can learn more about our mission, along with viewing previous lectures in the series at www.supremecourthistory.org. Our Civics Education and Democracy series is co-sponsored by the Anthony Kennedy Judicial Learning Center in Sacramento, California, as well as the Learning Center for the Court of Appeals for the Eighth Circuit in St. Louis. We're pleased to partner with them and look forward to additional learning centers in our federal courts joining us in the future. I'm very honored today that we're joined by a dear friend, the Honorable D. Brooks Smith from the Third Circuit Court of Appeals, where he served as its Chief Judge from 2016 to 2021 and is now a Senior Judge. Previously, Judge Smith served in the U.S. District Court for the Western District of Pennsylvania, and there he also served as its Chief Judge before being appointed to the Third Circuit Court of Appeals. He is the only judge in the long and distinguished history of the Third Circuit to have served as Chief Judge in both a district court and the Court of Appeals. Judge Smith has served in the judiciary for 38 years, having first started in the Court of Common Pleas in Blair County, Pennsylvania. His experience in both the trial courts and the appellate court have given him the full range of experience in judicial independence. He's also served at the highest levels of the federal judicial administration, having served on the executive committee of the Judicial Conference of the United States, as well as chairing the Space and Facilities Committee of the conference. He has recently written a law review article soon to be published on judicial independence and the rule of law. He can speak authoritatively on this topic. We're going to tap into Judge Smith's practical experience today and his view from the bench in our discussion. But first, we're going to take a brief run through the history of judicial independence and its evolution in American jurisprudence. And then we will discuss the future of judicial independence in the United States and some of the challenges we see to it. We will conclude with a discussion of some of the elements we see as crucial to sustaining judicial independence in the face of these challenges, specifically the importance of the rule of law plays in judicial independence, the importance of civic education to our citizens' understanding of judicial independence and the threats to it, and the importance of civility in our discourse, not only in the courtroom, but also in the judicial process and dispute resolution generally, and ways in which the judiciary can help itself in this regard. After Judge Smith and I talk for a bit, we will take questions from the audience. Please share your questions via the Q&A box on your Zoom menu. With that, welcome, Judge Smith. We're so delighted you're with us this afternoon, and thank you for taking time out of your busy schedule.
Thank you very much, Jim Duff. Good to be with you.
I think a good place to start would be defining generally what we mean by judicial independence, and then we'll hop into the history of it. Would you like to take a crack at that, or I can offer up a couple suggestions?
I would be happy to take a crack at it, and I'd be happy to hear any suggestions as well. I think it's important that judges be in the forefront of explaining what judicial independence is. And it really ties into your comments about civics education and the kinds of programs you're doing, because judges live it, judges embrace it. Judges, through their decision-making, demonstrate what judicial independence is all about. We know that what was intended through the structure of our Constitution and in the buildup to the Constitution, from the Declaration of Independence itself, where the long litany of complaints that colonists had about the king included, and I'm just going to read the words, he has made judges dependent on his will alone for the tenure of their offices and the amount and payment of their salaries. So it goes back to the Declaration and through the structure of the Constitution. But what does independence mean? It's independence to decide honestly, to decide by reason. And that too finds the expression in Federalist 78, where Alexander Hamilton explains just what the role of this least dangerous branch is supposed to be in the new in the new republic. So what is it? It means independence in our decision making, independence from the other two political branches of government. We can't be told what to do. We can't be told how to decide a case. We, as you well know, Jim, from your years as director of the administrative office, and so your work on behalf of the federal judiciary in so many important ways, that we still are part of a system and we must interact with the two branches of government, but they don't tell us how to decide. And that's why I think it's important for judges to talk about this, participate in civics education programs, and explain to the public what judicial independence means, because what we know it means is, I'm afraid, not always what the citizenry thinks that it is. It's not about just making it up as we go along. Law is largely determinate, but sometimes it is indeterminate, and we have to make decisions within certain parameters that require discretion as well. But we are not driven by partisan politics. And that's the message that I really think needs to be told these days.
Very good. And I think in sum, and you talked about roots and tracing it back to the Declaration of Independence and tracing it back to English law, but it's, and in some, it's free from pressures of the other branches of government, free from external and private influences as well. If we look, as you've done in your law review piece that I've had the privilege of getting in advance on, of tracing it back to English law, you can see, as was described in our own declaration, English monarchs routinely removing judges who stood in their way. And there, as a result, we saw the beginnings of judicial independence declared in the Act of Settlement in England, which provided two of the criteria that we've embraced in our own Constitution. That's tenure for good behavior, life tenure during good behavior, and fixed salaries, no reduction in the salaries. And then there they required the removal from the bench to require both houses of the parliament to be involved in that. And we imitated that similarly in our own the Constitution. But under King James, the treatment of the colonies by the courts and the crown in England was very different. You touch on that a bit too. I call you Brooks. I'll refer to you as Judge Smith for our audience, but we go way back. But Brooks, you mentioned that in your article, the colonies tried to avail themselves of this Act of Settlement and the English law. But what was the result of that?
Well, looking back, I think we had the benefit in a number of ways of the English experience, both the good and the bad of it, having learned a lot from the latter. And the Act of Settlement is a source. I don't know whether it's the earliest source, but it's certainly the most prominent source that I know of this term good behavior that finds its way into our own constitutional traditions, our own judicial traditions, not to mention, as you have, the need for a salary that cannot be diminished, and also providing, as it did, both houses of parliament having to act to force a removal. Some of that history, 17th century history, late 17th century history, is full of an interesting contest between King James and Sir Edward Coke. And Coke had a strong sense of really what a monarch was supposed to be subject to. And the monarch was supposed to be subject to the law just as his subjects were. But I'm not sure James had the same enthusiasm for that concept as Sir Edward did. And Sir Edward was eventually removed. A funny account I read was that actually Coke served as both the Chief Justice of the King's Bench and Chief Justice of Common Pleas. Unfortunately, I can't remember the order of it, but James removed him from the one and appointed him to the other, thinking he could do less damage there. And he still disappointed James and was fired. So Coke did what I guess every right-thinking Englishman would have done. He gave up on the bench and found a way to Parliament, where he continued, I think, to be an adjutant for the rule of law. We learned from that. And the colonists, though, suffered from some of the same deprivations that Englishmen had suffered from as well. The king, the monarch in England, really expected that the judges would serve the colonies, but they weren't prepared to pay them either. And the finances of the colonies were stressed, and the judges saw the difficulties of that, and hence the reference in the Declaration of Independence to the challenges those judges faced. So there is a history of centuries of experience here, challenges in the relationship between a monarch and a judge, and just how far the monarch's power reached, and where the judge was going to have some independence to actually decide without being fired, or worse. There were instances of worse sanctions than firings back at that time.
You mentioned life tenure and no salary reduction, which those are principles embodied in our own Constitution now. It's still remarkable to me within the United States that certainly our federal courts are given those protections for judicial independence, but many of our state courts are not. That is, judges are elected, and there are 38 of our states that have some form of elections for judges, and they're not life tenured positions. In your own experience, was the Court of Common Pleas in Blair County, was that an elected office or was that an appointed office?
Pennsylvania is one of those states in which every judicial officer is popularly elected. So that extends from the so-called minor judiciary. Used to be justices of the peace. Now they're I can't remember the term that has changed several times over the years, through the Common Pleas, through the Superior Court, Supreme Court. All are elected. The judges are elected for 10-year terms, and then after the service of a full term are subject to a retention election, a simple yes or no. What we've watched over the years, especially, and this is probably especially in smaller counties where Common Pleas Court judges sit, is especially in a populist part of our history like now, judges can be much more subject to politics, if you will, or political issues boiling up and really becoming issues in their retention elections, not simply their initial elections. And so you've seen, despite the simple yes or no, during the period of time that I've been in the law, and the period of time during which I've been a judge, of seeing judges voted down simply because people have been unhappy with decisions. Smaller counties, sometimes they've been for nothing more than a judge passing upon the legitimacy of a real estate tax assessment, but never very popular.
Well, you've had the full gamut of experience with regard to judicial independence in your background, and certainly can speak to it with authority. Early in our history, there were conflicts, as they continue to be, I think, throughout our history concerning the composition and appointments to the courts. We saw early in our history, Congress passed the Midnight Judges Act, which established a number of new judgeships that was to be filled by the outgoing Adams administration. And then that act being repealed after the Democratic Republicans took office. Can you describe briefly what that led to, and then we'll talk about the Marbury versus Madison decision. We're going to take a quick run through our history so we can get to current day events. And I think we have enough material to fill 2 hours, but we only have one, so I'll try to move us along.
Well, the Midnight Judges Act is a great example of a way in which one of the political branches, or both political branches, can exert force upon the judiciary or attempt to impact the composition of the judiciary. This just happened to be the first real conspicuous occasion when it happened in the early history of the United States, as the Adams administration was wrapping up. And in fact, if I recall, John Adams did not attend the inauguration of his successor. I think I recall that correctly. In any event, obviously there was an attempt to get these new judges in office before the new Jefferson administration took over. And we'll perhaps talk about efforts to do something similar later on. But this was a sort of court packing, if you will. And it did lead to an attempt to remove these judges, essentially through a technicality having to do with the receipt of a commission. As most people know, I went back and reread not all that long ago Marbury versus Madison. I had forgotten that the report and the opinion itself is actually fairly long and rather dense. But we all know the most important part of it, and it really is an extraordinary introduction, I think, to the notion of judicial independence. It makes one really marvel at the understanding that John Marshall had of how this new republic was supposed to conduct its business, and how the three departments provided for under the Constitution were to, in some instances, interact. And really, the opinion dealt with the authority and the role of both of the other two branches of the government in various ways, in dealing with Madison, who was then the Secretary of State. Congress, of course, had enabled the new judges. And I don't know how many times I've read it and heard it, but those really fairly simple words, it is emphatically the province and duty of the judicial department to say what the law is. What a very simple but powerful, robust way of setting out what the authority of this judicial institution really is. And we have that as our heritage, and have built on it. He demonstrated certainly his own independence. One wonders in that decision how it may have affected the often difficult relationship between John Marshall and Thomas Jefferson, who were distant cousins and apparently had some differences over the years. But he set out the role of the court, which may not have made many people happy, but he also addressed an issue of jurisdiction of the court and the result that was reached, and what the Constitution said about the jurisdiction of the court.
I thought you did a very good job in your soon-to-be-released law review piece, describing the fact that the founding generation could elevate judicial independence on the one hand, and yet undercut it with the other. And we see that thread kind of working its way through our history. But fortunately, the Constitution has prevailed, and those such as Chief Justice Marshall, who led the way in articulating and defending that independence of the judiciary, has prevailed over time. One of the other things you did very well, I thought, Brooks, in your piece, was divide the eras of eras, not errors, but of judicial independence into three categories. And we've touched now on the early era in American history. Let's go to briefly the middle era of judicial independence, where the focus was on federal supremacy in judicial dissensions during that era. But there were still some inter-branch conflicts, certainly, that arose in that middle era of judicial independence. Martin versus Hunter's lessee. There we had the enforcing federal laws over the state laws. Worcester versus Georgia, the challenges to the court's authority there, where an individual who was living on a non-Native American who was living on Native American lands was indicted under Georgia law for living there on Cherokee lands without a license. And the court said, the Supreme Court found that this violated the Constitution and treaties of the United States. And the court sided with the Cherokee Nation in this battle. It did get some pushback, as you are articulated in your piece. You might describe that, and we'll jump next to President Lincoln's actions.
Well, I should have said at the very beginning of our discussion, Jim, but by now I'm sure it's obvious. I am anything but a history scholar. I am someone who has a tremendous interest in reading history, and I always have history and biography in my collateral reading. So this three-part history that I constructed in the article was really for ease of my own discussion. I can't claim it to be something that has been endorsed by academic historians, but it seemed that the founding era was especially important in terms of setting us in the right direction, which, as I've attempted to underscore, I think Chief Justice Marshall certainly did, and others did as well. And then this middle era, where with the institution having been put in place and having been given some definition, the court began to assert itself in various ways. Marbury versus Madison was, of course, the first occasion, and it was a long time before there was a second occasion that the Supreme Court of the United States knocked down a federal federal statute. But much of the activity in the ensuing years was in addressing state laws, state legislation. And I suppose that shouldn't be surprising, given the fact that our colonial roots and the states which became the Union did have their own identity, their own loyalties, and their own laws, their own courts. And so it became necessary for the Supreme Court to assert itself, certainly in one of the cases you mentioned, Martin versus Hunter's lessee, where it fell to the Supreme Court to strike down a state law that actually went back to and affected the property rights of those who had been loyalists to the crown. And that probably in and of itself required a certain amount of courage and a certain amount of judicial independence. I've always thought that the difficulties I mentioned earlier, the occasional difficulties in the relationship between the two Virginians, Jefferson and John Marshall, provided some interesting insights to some of the events of the times. But of course, when we get into Worcester versus Georgia, and the whole period of the Trail of Tears, Cherokee Indians. And what may or may not be an apocryphal story, but the story that has been recounted so many times about the decision of Chief Justice Marshall, which did not exactly gain the approval of President Jackson when Jackson allegedly said, John Marshall has entered his order, now let him enforce it. Just as John Marshall's words in Marbury versus Madison so eloquently and plainly set forth what the authority of the Article III courts are, the alleged statement of President Jackson certainly lays bare the limitations on the courts. Again, going back to Federalist 78, Hamilton states explicitly in there that the third branch is going to be subject to the need of the executive to enforce its orders. And now what happens when the executive doesn't want to do that? And we see questions arising as we move forward more toward the present time, where we have concerns about that. But fortunately, our traditions and our norms, not to mention the support of the public, the quiet support of the public, have seen to it that those situations where the court's authority might have been tested were not tested in the ways that could have been constitutionally and in other ways very damaging to us.
Well, we're getting questions already about your law review article. Maybe we could address that right now, when and where it would be published. I know we've piqued some interest in it, so let's take that one on now. And then I'm going to move us ahead through history pretty quickly here, so we can get to the present day and your observations.
Well, it's the piece will be published in the Lewis and Clark Law Review. I had spent about a week and a half out there in October as a guest of the law school in a program that they have had for some years, and I gave a lecture that became the subject matter of this article. So it's been and actually that came from a presentation that I had given last summer at Cambridge as part of a continuing education for lawyers program at Waynesburg University here in Pennsylvania. So it's something I've been working on, and needless to say, Jim, you and I have known each other a lot of years, and having done this work for a lot of years, it's a subject that's near and dear to my heart, a subject I've given a lot of thought to. And I have to confess that it's a subject I've given a lot of thought to in recent years, even more intensively.
Well, thank you for sharing your experience, and we'll move on from the middle era toward the end of it. Maybe it's about a century later. I'll move past President Lincoln's suspension of habeas corpus and his confrontation.
Not his finest hour in the eyes of some or many.
But you do describe in more detail in your piece about the frictions between the branches and among the branches throughout history very well, and how judicial independence has asserted itself. And then in that case, the habeas suspension, the court took it on, but it was after the Civil War, and sort of easier to come down where they did, I suppose, post-Civil War than in the midst of it. But let's just talk about the court packing plan, President Roosevelt's court packing plan, and then we'll move very briefly into the modern era before we talk about the present day.
What I have found remarkable in my reading of the reaction to the court packing plan is why it didn't work. We know that FDR was very displeased with a number of the decisions of the Supreme Court that addressed public health and safety regulatory measures that the Supreme Court had struck down. And he wanted to find a way that that could be addressed, and the ship, in his view, could be righted. And so he attempted to legislate the increased size of the court. Interesting to note that we have seen a more recent iteration by some of such an effort. It remains with us. The number of sitting justices has not been a fixed number from the very beginning of the court going forward. But what I find remarkable, and maybe it's remarkable because I'm looking, and so many of us are looking today at the temper of the times, is that there were members of FDR's own party who reacted very negatively to this plan. People, I think, truly understood that there is such a thing as payback, and if you start this, you don't know where it's going to end. So very responsibly, I think, members of Congress, especially a number of senators, made it quite plain, including senators of FDR's own party, that this was a bad idea. And so it did not go forward. And I think fortunately so, because had it become a precedent, if you will, it would have suggested that this was an alternative always to a court that wasn't particularly viewed as being congenial to a particular administration or political party for that matter.
Move to the modern era, and I want to touch on one case from the modern era that, and it's a story that you and I are fond of, that you tell so well about judicial independence, and you might just go to that story, Brooks, please, and then we'll talk about the current challenges that we see and threats to judicial independence.
Yes, I know what you're referring to, Jim, and it harkens back initially to Watergate and the Nixon case that went to the Supreme Court. It's a story, a wonderful anecdote that Justice Souter related to the judges and guests of the Third Circuit at one of our judicial conferences, just at the time he announced that he would be retiring from the court. It has particular meaning to me for a number of reasons. Two reasons, though, that are personal to me. One, I have done over the years a fair amount of rule of law work in other countries where the notion of judicial independence is not a concept that exactly resonates with the judges, or certainly with the public. And also because I was in law school, finishing up law school, during the latter Watergate days. And so hearing this story, both from the work I did in Russia and from this very formative period in my own legal career, meant a great deal. Justice Souter told of a visit he had from a young Russian man. The young man, I believe, was at least either studying to be a lawyer or had become a lawyer. The justice had a friend who had asked him if he would entertain in chambers this young Russian man. So the visit took place, and Justice Souter, after a conversation with the young Russian, took him to the conference room. I, by the way, Jim, have never visited the conference room. So if you have any influence that you might get me in there sometime, I'd love to see it. But anyway, the discussion went on, continued, and Justice Souter thought he would ask the young man, who had demonstrated quite an understanding of American jurisprudence and American judicial history, what case what Supreme Court decision did he think was the most important? And Justice Souter quickly told his audience that what he expected was that the response would be Brown versus Board of Education, which so many of us would probably expect to be the answer. And the young man, as he treated the table as almost a holy relic, he was putting his hand on it and sweeping his hand across it, and he said, no, the Nixon case, the Nixon tapes case, because in my country, that would never happen. And those are stirring words. It's a great anecdote, and Justice Souter told it far more eloquently than I could ever tell it. But it presented a wonderful contrast. First of all, it was affirming to those of us who believe that what we do matters, whatever level of the judiciary we serve at, but also to know that in our history, in our relatively modern history, that the center held. The judiciary did what it was supposed to do. It stood up to a president of the United States, and the president backed down. And so it is certainly affirming also to know that someone, and hopefully numerous people from other countries, recognize what we have. And I hope Americans recognize that as well.
Thank you. You did a wonderful job telling the story. Thank you for sharing that with us. You mentioned the Third Circuit Judicial Conference, and that will lead me to sort of next category of discussion, and that is current judicial independence. I raised the Third Circuit Conference in this context. You know, we have in our system of government, with regard to judicial independence, I think two forms of protection. One is the constitutional protection that we've discussed, and you've done such a good job of articulating those constitutional protections of life tenure and no reduction of salary. There's also institutional protection for the third branch, for institutional independence, and it's created through our circuit structure, our Judicial Conference of the United States, which pulls together, as you were Chief Judge of the Third Circuit, all the chiefs of all the circuits and district court representatives from all the circuits to basically engage in the supervision and rulemaking from within the judiciary. Can you speak from your experience as having served on the Judicial Conference as the chief of your circuit, and also as chair of the Space and Facilities Committee, one of 25 different committees in the Judicial Conference, how important that structure is to the notion of, in reality, of judicial independence?
It is enormously important. It is effectively a form of self-governance, the governance being limited to those areas, of course, that affect us and our administration, and as you've referred to rulemaking as well. But having seen it, having participated in some ways in this form of judicial self-governance, I have to say it's hard for me to imagine what things were like before we had the Judicial Conference. We have, of course, Chief Justice Taft to thank for initiating the process that gave us the Judicial Conference of the United States. The more you read about President Taft and Chief Justice Taft, the more you become aware of how much more he enjoyed being Chief Justice than he did being President of the United States. And for those of us on the bench, we can certainly appreciate what he did by initiating a process which gave us the conference. Its various committees, which make recommendations where required to the conference and upon which the conference takes action. Also, some of the interactions that the conference processes through committees also require us to deal with the other branches of government, budgetary issues. We have a budget committee, as you know better than I. Our whole rulemaking process, the various advisory rules committees that we have for civil, criminal, bankruptcy, evidence, appellate, the standing committee that I'm now serving on, and the way that process works in requiring the rule to actually take a path that gives Congress an opportunity to look at the rule, that gives the Supreme Court an opportunity to speak on the rule. So it is truly, some might think, a laborious process, but it's intended to be just that, for public input as well as for the judiciary itself to have input. Really a remarkable thing. And while I am no expert on comparative judicial institutions, I've seen enough of them from my rule of law work to say I've not seen anything really close to what we have in this form of self-governance.
Thank you for articulating that, Brooks. It is an important element of it. And one of the threats that we see to judicial independence, however well-intentioned, can be legislation in Congress that, in my view, you don't need to speak to this, but can take things a bit too far. I refer specifically to a bill introduced in the last Congress called the Judicial Accountability Act, which was perfectly well-intentioned in that it was rooted in something we all can agree upon, and that is protecting employees from harassment in the workplace, something that the judiciary has taken very seriously in recent years, and taken some action to improve its processes and procedures that it provides to employees. The Congress, some in Congress were wanting to encourage more action by the branch, but devised a proposed law that would create a new system of oversight for employee complaints that would report to the Congress and the president, and would give subpoena power to this new entity that reports to Congress and the president. It struck many of us who working within the branch as something that would infringe greatly on and could be abused to target judges that the other branches didn't particularly like, or their opinions they may not like for investigations. There was a lot of potential for abuse that we saw in it. And so we spoke out about it, and the bill did not move. But I raised that in two contexts. One, how well-intentioned legislation could infringe on judicial independence. And two, the importance of civic education in our public to recognize such threats and to weigh in on that. And can you speak a bit to the importance of civic education? And I also want to lead into the importance of civility in our discourse, which is something I think you've spoken very well about in the past.
The Judicial Accountability Act, as you well know, and you are more an authority on the actual proposed provisions within it than I am, but I did spend time reading it in its entirety. Two very disturbing aspects to this when it was first introduced, and it remains to be seen, I believe, whether it will be reintroduced in the new Congress. But I'm sure it was of concern to you that many members of Congress, certainly members even who had an interest in this specific act, were not aware of how much the judiciary had already done on its own to address workplace problems. The Chief Justice very correctly identified this a number of years ago as something that he wanted the judiciary to address on its own, and we did. And we undertook studies. We had working groups, and we still have a working group addressing this. So to make a workplace that is congenial and friendly and appropriate. So some of what the JAA sought to do was to replow ground that we had already plowed. The other thing that I think is conspicuously disturbing is the name itself, the Judicial Accountability Act. Accountability to whom? I think I know what was intended, but it does alarm me that that word would be used and cause people to wonder whether we were going to be accountable to Congress for exactly what was going on in our own workplace. So it was a reminder once again, and certainly a very chilling one for some, and a broad attack, if you will, on what were perceived as current practices, or a refusal on the part of the judiciary to address them, which was just entirely wrong. So hopefully we have seen the last of that. But there's always a new Congress.
Thank you. We're going to take questions from the audience, and I invite you to submit them in the Q&A section on your Zoom. But and some are coming in. One of which I think leads to one of the last couple of points that we wanted to cover today, and that is the importance of the rule of law. And a lot of what you and I have been discussing today is sort of a vigorous defense of judicial independence, but it is also rooted, I think, as you've so well explained in your article, in the rule of law. And one of the questions that we received already from the audience is not judicial restraint and the respect for the judgments of Congress equally as important as judicial independence? And Brooks, if you would please talk about your views about the importance of the rule of law and what that means in the context of judicial independence, lest we be misunderstood as to just how far judicial independence really goes.
Yes, and that the potential for that misunderstanding is precisely what I think it is incumbent on the judiciary to address as frequently as we can, and to do so in civics education programs. I frankly would consistently tether to the term judicial independence the term rule of law, because judicial independence is exactly what the rule of law is about. The independence is to allow the judiciary, through its resources and its reason, as Hamilton referred to reach a decision. We don't draw upon other sources. We look to law, whether it be statutory, whether it be common law, whether it be regulatory. Our decisions are based on rules, so that judicial independence is part and parcel of the rule of law. It draws on it. It not only draws on it, the rule of law is essential to judicial independence. So as I started out when we began this conversation, judges understand that, but I think the general public does not. And probably a lot of that is our own fault. And it's a great thing to see the programs that you are doing, the programs that so many courts and so many circuits are doing anymore, real outreach to try to tell our story, if you will, what we do, how we do it, why we do it.
Very good. And what about the importance of and how the judiciary can help itself in this regard, the importance of civility in our discourse? If you would please share with us your experience with the Third Circuit, which is really, I think, a model.
Thank you, Jim. And I'm always been very proud of our court and of the ways in which we interact and work with one another. We can disagree. We, as I referred to earlier, most of the time law is determinate, but it isn't always. Sometimes we do not agree on the outcome or even the reasoning of the decision. And so we have to go our separate ways. But we should do so. And on the Third Circuit, in my experience on that court over a little more than 20 years, and we have always done so in a collegial manner, politely, always realizing that we're going to come back and sit together again and decide cases together again. I'm a little disturbed by some language I see from time to time in the present day that is a bit more combative than what I've seen in the past. I'm not referring to my own court, but I've at least read news media reports, and it's something we judges need to keep in mind. It makes for great ink if you're in the news media to draw on differences between judges and what seem to be sharp exchanges between judges. And if for no other reason than the fact that it does make for a good ink is probably a reason to avoid it. And it's not the kind of message we want to send to the general public either. We are not politicians. Our disagreements are over law. Our disagreements are what law leads to in terms of result. And it's great when we can be unanimous. I have a strong belief that the law and courts are at their strongest when they speak with one voice. But it can't always be so. And I was thinking just yesterday, as I considered our program today, Jim, that dissents, which I've not really been drawn to real often. I haven't authored a lot of them. I find it better to try to find a way to join. But they require judicial independence as well. That independence of thought on a court of appeals, where we're almost always sitting on panels of three, someone has to say, no, I feel strongly enough about this that I have to go another path. And that other path may be to a different result, or it may be to the same result, but it may be with different reasoning. So one writes a concurrence. But the important thing is we are doing it pursuant to a rule of law. We are always expressing, we are always looking to and then expressing our positions based on a rule of law. And we just need to also do it in a congenial way, in a collegial way as well, and make the kind of impression to the public that judges ought to make.
You've answered a great question that we just received from our audience. In part, you've touched on the answer to this, but I think it can use more specific response. And the question was, what can be done to restore civility in the Supreme Court judicial nomination process, which I would add is federal judges as well, in addition to the Supreme Court judicial nominees, but in the criticism of major Supreme Court decisions.
I wish I had an answer to that. I think it would really require a degree of Solomonic wisdom to come up with that, with a solution to that. And I also think that it's important to emphasize that that the politicization, and that's what it often is, the dramatization, and that's what it frequently is, of confirmations has certainly been a major source of the public's perception that this is a politicized job. This is a politicized process. I'm referring to the judicial decision-making process. And that's unhealthy. And it has, I'm speaking to the confirmation of those of us on inferior courts as well, because the process in my years in the law has reached down much more frequently than it used to be to Court of Appeals nominees and even the occasional district judge. So it's oversight is critical, and the Senate has a very, very important role. This is not a matter of of rubber stamping anything, and that's not what judges expect. But I think most people who have gone through the process understand that it's turned into something that it shouldn't be. I've talked to U.S. senators in the past who have told me just that. But as you and I have discussed before, the interest groups have become very much a part of this process. They have their contacts with the congressional staff, and they will feed congressional staff. And interest groups make money by ginning up these efforts. So it's a process that has become something that it should not be. But whatever can be done to get it back on track, judges, I'm afraid, are the last people who are going to be asked to do that. It's the Hill, it's the Senate, it's their staffs who really have to look for solutions to humanizing it again.
We're putting together a group of interested people who are very devoted to returning the nomination process and the confirmation process, restoring regular order to it, as we've described it, to see what we can do to move in that direction. It's very difficult for an individual to go through the process these days and come out the other end and not appear to be politicized and to not appear to be anything but independent. And it is one of the threats we see to judicial independence is the process. So we do want to try to restore some civility to that process. And I know there are interested people in talking with the Senate about the confirmation process. There's so much more to cover, but I'm afraid that we're out of time, and we had some good questions. I think you've touched on most all of them, Brooks, today, and we're very grateful for the time you've devoted and can spend with us this afternoon. So we'll sort of stop there on the question and answers, and just give you our thanks for your willingness to step away from all your busy responsibilities on the Third Circuit.
Thank you very much, Jim. I've enjoyed this. It's been great to have an opportunity to work with you again.
Well, thank you, Brooks. The next lecture in the Society's Civics and American Democracy series will be scheduled shortly, where you may look for an announcement on our website for details. And I would encourage you also to visit our YouTube page for previous discussions on these topics. We had one, for example, with Kim Shepley, who is a professor at Princeton, and she spoke to independence and threats to independence in her studies from Princeton. And Judge Smith actually introduced me to Professor Shepley, and we were grateful for that. So there are other programs on these topics that you may visit on our website. The Society is next hosting Professor Laura Kalman on March 2nd at 7 p.m. for a conversation with Professor Brad Snyder on her new book, FDR's Gambit. Registration is open and available on the Society's website. The Society's Law Day lecture is also open for registration. Professor John McKyle will be speaking on May 2nd at noon on James Wilson and We the People. I hope you will join us for both of those events. A survey will go out later today. We encourage you to take time to fill it out. We take your feedback very seriously, and we use it to build better and more informative programming as a result. And with that, we are concluding today, and we are adjourned. Thank you again, Judge Brooks Smith.